Morning, everyone.
Morning.
I'm Jo Howard. I'm an employment law solicitor from Thompson Solicitors. I've been practicing now for about 10 years, but over the last 4.5 years or so, I've developed a practice in professional conduct cases. So I represent registrants before the Nursing Midwifery Council, Health and Care Professions Council, a teaching agency, and I've also done a case before the Royal College of Veterinary Surgeons. So it's an area that is unfortunately for registrants growing in terms of the number of complaints that are made year on year. And part of that, I think, is because we are very much living now in a complaints culture where we are encouraged to be complaining about any service that we receive. 50 years ago, people probably wouldn't have thought twice about making a complaint about a doctor or a nurse. These days, we are encouraged to do so. And the regulators are there to oversee our professions and to ensure that practices are carried out to a high standard, and rightly so, because as a member of a profession, you should be proud of the fact that you're a member of that profession and want standards to be high within it. Hopefully you would have all picked up a copy of the handout. I'm really sorry that my slides aren't particularly interesting, but I realised when I was drafting this, I know absolutely nothing about PowerPoint. So this is the best that I could do.
Let's get it up. Just want to help.
Oh, it's up there, isn't
the
it?
full screen? Could we get the full
Oh,
screen?
I don't know how to do
Don't
that.
worry, don't worry. See if we can help you. The screen's not showing actually. Oh, here we are. I'm going blind. Where's the full screen? Can anybody see it from here? Is that it?
It's just at the top.
Oh, it's right at the top. It's slightly
Slide
different.
Slide
Where are we? Ah, there we go.
Yeah, that's it. That's it.
There we go.
Oh yeah, that looks much better, yeah. So now you can see them in their full glory. Full glory. So within your little pack, I've just given you copies of like the OHPs that I'll be working off today. Or they're not really called OHPs now, although they are PowerPoint slides. There's the NMC guidance on record keeping. That's a very useful reference tool. The NMC have a pretty good website. It's not my favourite of the regulators' websites. They're not my favourite regulator, but it's quite a helpful reference tool. There's also like a little checklist on record keeping that you might want to pin up on a notice board, but in some respects I'm preaching to the converted, I suspect. There's a little bit on the Access to Medical Records Act and the data protection principles. And they might just be of general use to you in your everyday life should you want some subject access at any time. So... So this morning I'm going to have a look at why is record keeping important, what do good records contain, record keeping and the law, so general overview of the sorts of legislation that might pop up from time to time, confidentiality, and then a little look at the fitness to practice regime and where all this might fit into your actual day-to-day practice. So why is good record keeping important? Well, patient care is twofold really. There is the personal care aspect, but there is just as important the documentation aspect to it. And those two things hand in hand are the only things that can make up proper personal patient care. Now, but record keeping, it's not to be seen as a chore. Unfortunately, it is fundamental to the profession you are in, much like it is fundamental to mine. But unfortunately for you guys, if you're working within the NHS, then the Public Records Act says that NHS staff effectively are obliged to keep medical records, and those medical records, every one that you write, is a public record. So from the very outset, they have a very significant value. Luckily, mine are just pieces of paper that I print out of a telephone conversation and put on a file. But for you, it's much more serious than that. You also have a duty as an employee. Every trust that you work within, or if it's within a private organisation, then they will probably have, and a trust will definitely have, its own record-keeping policy. There is no sort of sets a standard in terms of what notes have to look like, but there are common themes in terms of what they should contain. So every trust will probably have its own house style. Some, or I imagine most have rolled out sort of Rio systems now, but we have a system where there are probably paper records and electronic records operating within working environments these days. There will be rules that are apparent to both of them. You also have a duty as a registered health professional. The NMC are there looking at your every move, whether you like it or not, and whether you know it or not. Record keeping and a good and a high standard of record keeping is one of the tenets of the Nursing and Midwifery Council standards in terms of their code on conduct, performance and ethics. Record keeping is ultimately integral to good practice. It's a way of identifying risks, whether that is a risk to the patient themselves or a risk that the patient may pose to health professionals, whether it is about the risk that you may pose in terms of clinical audits and if your records aren't coming up to scratch, and in terms of, dare I say, clinical negligence, but we won't really touch on that today. Every record is about a record of a service user's progress and their journey effectively. It's your means, or your only means really, of communication with your colleagues, whether you are referring a service user on to another health professional or in terms of your own actual record of your own interaction with that service user. None of us can guarantee that we're going to be at work tomorrow. We might end up under that bus that seems to keep running everyone over, or you could end up with a 24-hour bug. Anything could happen, so your records need to be relied upon by your colleagues, and so there has to be enough information contained within them for someone else to pick up that service user's notes and be able to see their journey and where they need to go from here on in. Care is about it should be seamless, and so that's not necessarily reliant on you, but as the service provider as a whole. As important, I suppose, it's about your self-protection. They say that now that 1 in 3 health professionals at some stage during their career will be involved in some kind of litigation. So that's a pretty high statistic. That's not to say that it's all going to be about fitness to practice. It could be any manner of other claims that a trust is exposed to. The service users that you deal with day in, day out, they are one of many to you, but to a service user, they are the only one going through what they're going through. They will remember everything you have said to them, perhaps not quite as you have said it, which is why it's important that anything you have said to them is contained within those notes. So if there is ever a conflict that arises, you can point back to those notes and say, this is what happened, this is what I recorded. The golden rule, is if you take nothing else away from what I have to say to you this morning, is if it's not there, it didn't happen. It's like you have no way of demonstrating to anyone, whether it be your employer or a regulator or a court of law, that something happened. So always make sure that you do document everything. Ultimately, if you do find yourself in a situation before a regulator, then a judgment will be made about your conduct by virtue of the fact if you have shoddy notes, then it's quite easy for a panel to make some sort of conclusion about and the other aspects of your care and your sort of the role that you do are shoddy in nature. So just make sure that everything is there in as much detail as you don't need essays, but you need as much detail as is necessary for someone else to be able to pick that file up and know what happened and what needs to happen in the future. So what do good records contain? Well, they should contain your care plans, any decisions that you have made and the basis for those decisions, the care that you have delivered, or perhaps the care that you have not delivered and the reasons why you have not done certain things, and the information that you have shared with the service user and any comments that they may have had about the care that you have, or the information that you have given them. Your record should ultimately be showing why you have chosen to take a certain path. And it's your opportunity, if you like, to show that you have been applying the skills and the knowledge that you have to this particular service user and acting in that service user's best interests. Your notes should be accurate. They should sort of record the fact that a patient or a service user may be at risk or a risk to other health professionals. That should certainly be there. Ideally, the notes should be in a chronological order. That's not to say that amendments can't be made or additions made at a later time, but what you should not be doing when it comes to manual records is whipping out the Tipex and deleting sections of text. No. If any amendment is to be made, it should be with a single line so that ultimately what's underneath should still be legible, and then you write the amended note and sign and initial and date it. The same really with computerised records. Do not be pressing the delete key at any time. Once that record is there, it needs to stay there, and if you're making any amendment, then just make the amendment underneath explaining why the amendment is being made. If you are making a retrospective note, then that's fine to do so, but please make sure that you do actually write written in retrospect. I have a case before the NMC at the moment with a midwife who has been, well, one of the major criticisms with this midwife is her standard of record keeping, and her writing is pretty neat all the way through and nicely spaced out, but there are sections where really it's quite obvious that she has gone back and squeezed writing into a particular line. Her instructions are that didn't happen, they were written contemporaneously, but ultimately I think when a panel look at it, it's going to look as if writing has been squeezed in, and that's the danger that you face. But if ultimately there's no harm in saying, yes, that is written in retrospect, I may have forgotten to write in retrospect at that point, but it would be much easier to deal with that particular allegation if those were my instructions. Your notes should be contemporaneous, but as covered earlier, it's not always possible to be writing contemporaneous notes. The NMC say that your records should be made as soon as possible, but really they must be made within 24 hours. If for any reason they're being made outside of 24 hours or at any time after the event, again, just make sure it's written in retrospect. Your notes should always be legible, especially if they're handwritten. It's obviously easier on a computer these days. If they are handwritten, then really it should be in black ink. Notes will, at some stage, possibly need to be photocopied, and so that is the best of the colours to use in terms of making sure that any copies are subsequently legible. Your notes should be free from jargon, humour, abbreviations and assumptions. So using a word such as appears, so Ethel appears not to be mobile. Well, Ethel either is or she isn't mobile, so make sure that your notes are actually pinning that down, because otherwise it's looking as if you're not examining the service user sufficiently. Humour, and this feeds into abbreviations really. It's like Ethel fell over the cat today, LOL. Not the right place for those sorts of terms to be cropping up. Abbreviations, some abbreviations like BP, it's recognised within the profession that you're talking about blood pressure. Other abbreviations such as PT could mean anything. It could be patient, physiotherapist, to me it means part-time. So be careful about the abbreviations that you're using. Generally, some trusts will operate a system where they have recognised abbreviations that can be used. So make sure that you are keeping to those and not making up your own shorthand effectively, which when someone else comes to look at it, can't be understood. Goes without saying in some respects that notes should be signed, dated and timed. It's amazing how many notes that I get to look at, that tiny little thing, which really once the record has been made, it takes a millisecond just to sign, date and time it. hasn't been done, the first time that you are signing and dating, you should also print your name as well, so that it's quite easy for someone to recognise your signature throughout the notes. So that's my sort of précis of what good records should contain. In terms of record keeping and the law, we've already touched on the Public Records Act of 1958, and that's placing an obligation on you to keep medical records. There's also the Access to Medical Records Act of 1988, and one of the pages of the handout refers to this. This is if you're being asked to draft a report on the physical or mental health of a particular service user that you have medical responsibility for. The service user has a right to see that report before it gets sent anywhere, and must consent to that report being made in the first place and then being sent on. And so the little synopsis in the handout tells you the timeframes that are involved there. These sorts of reports are commissioned for employment or insurance reasons. So with the insurance, it'll be if someone's sustained a personal injury of some sort. The Access to Health Records Act 1990 is pretty much defunct now. Most of it's been repealed and replaced by the Data Protection Act. But what it does do, it still covers the deceased. So if any medical records need to be obtained for someone that has passed away, then it will be the Access to Health Records Act that is referred to. The Data Protection Act 1998 is something that we will all be familiar with, in terms of it crops up on the news or in newspapers quite frequently. Every time I think about it, I get butterflies in my stomach, because when we come to look at confidentiality, it's a minefield. I think I breach the DPA pretty much every day. It applies to those that process and store personal data, and medical records are recognised as being personal data. Anything you write in your records can be obtained by a service user if they want to pay the prescribed fee. That's £10 for electronic records, or £50 for paper records, at the maximum of. So anything you write could be being read at a later date by the person you've written it about. So just be conscious of that as well, in terms of anything or opinions you might be expressing in your notes. Would you want the service user to see that? Would you be okay with them reading it? The Data Protection Act has a number of principles, and that's part of the handout as well. The principles relate really to your obligations anyway as a health professional, in terms of what your notes should contain. So they must be adequate and relevant, accurate and up to date. And so that applies, like the up-to-dateness can be simple things in terms of updating a service user's address or a telephone number. If those details are not kept up to date, then technically that is a breach of a Data Protection Act principle. So then we have the Freedom of Information Act 2000, which again is something that crops up in the press quite frequently, because it's become very popular now for people, especially people who love litigating, to make FOI Act requests to public bodies. Any NHS trust is going to be a public body, and so Freedom of Information Act requests can be made, but although they can be made, they can't be made by a service user to obtain information that relates to them as an individual. The Freedom of Information Act is there for people to gather information about a trust generally. So how many clinical negligence cases have they been involved in? How many staff have they recruited or dismissed over the last 3 years? It's those big general questions rather than subject-specific questions that Act relates to. So confidentiality. As a health professional, you have a duty to keep the information that is passed over to you by service users confidential, much like I have a duty of confidentiality to the clients that I come into contact with. one of the Data Protection Act principles is about security, and it's a minefield, I think, in terms of what could potentially go wrong and the practices that we undertake day in, day out. When it comes to storage, well, I mean, once a health record has been created, then there's an obligation for that health record not to be lost, not to be damaged, not to be destroyed, and not for anyone to have unauthorised access to it. So with manual storage of records, generally you would expect those to be kept within locked filing cabinets, potentially within a room that has restricted access, but not always. With computerised records, you would generally expect there to be some form of audit trail that was accessible on that for those computerised records. So at any point someone creates a record or amends a record, or dare I say deletes the record, that can all be accessed by someone with access to the appropriate server. USB sticks, I mean, I've bought a USB stick here today to do this. I don't have a clue what's on that USB stick, and they are used quite frequently, maybe less so now because we're having all of this cloud malarkey that started to develop. So, but on a USB stick, it's probably not protected. You probably don't have a record anywhere of what might be kept on your USB sticks. So really, they should be avoided at all costs, potentially. I'll be destroying mine when I get back to the office. In terms of most of your patient records will be kept within an office environment. And if they're kept, well, they shouldn't really be stored out of the office, but there will be occasions when you are out in the community that you need to have patient records with you. Trusts will generally have some form of policy in terms of what needs to be adhered to when you're taking patient records off of the premises. Whatever you do, do not store your patient records overnight in a car. Cars have a habit of getting stolen, and if they don't get stolen, then it's quite easy for someone to get access to the boot and take a bag or a box out of it and run off, and then you don't have your patient records anymore, and it's going to be a breach of the Data Protection Act. Not only that, it's going to get you into serious trouble with your employer and potentially the NMC. It is amazing that records do seem to have a life of their own. I mean, I've had cases where people have left records in the boot of a car and have gone missing. Cases where filing cabinets have been emptied and the files have been stored in boxes ready for an office move, and the boxes have gone missing, thought to have been thrown out by the cleaning staff, but no evidence of exactly what did happen to them. Records where people have taken them home, stored them under their bed, separated. I had ended up with like 2 packs of records, lost one of those packs. It's a bit of a minefield. If you are looking after patient records overnight, then ideally you'd put them in a safe or a panic room, but we don't all have those in our houses. So the best you can probably do is to keep them in a locked storage bag rather than a bag that it's like a carrier bag or an easy access bag, and pop it into a room that doesn't tend to have access. So you can't be accused of any of your family members or friends that pop round having access to the records, because that is something that if notes are at home overnight, then there will always be the question asked about, well, who was there? Would they have had access to the records? So if you can keep them in some sort of dark, dingy cupboard somewhere, at least you can say that they were in a locked bag in a particular cupboard. No one would have had an opportunity to have access to them. When you are carrying patient records around in a bag, as well I know I do, just be careful. I mean, the Information Commissioner is really stamping down on these data protection breaches now. Someone from Croydon Council lost a bag that contained some sensitive personal data, and the council was fined £100,000 for that breach. I was carrying 2 files home about a year ago in a slightly inebriated state, and my boyfriend took my bag and I lost him on the tube. I panicked about where those notes were because he was in a worse state than I was, and thankfully, he did turn up without his laptop, but with my bag of files. And I've never been so relieved at losing a laptop in my life. Thankfully, the laptop turned up the next day as well, thanks to a good Samaritan in Ealing. But it's easy done, and it's one false move, and it creates all manner of problems for you, your employer, but ultimately you. Because that person at Croydon Council, you can bet that they're not employed anymore. There was an occasion, it was probably in 2011, but the actual appeal case was 2012, of Central Community Healthcare Trust, who were inadvertently faxing the health details of cancer patients to, they thought, a hospice every Friday, and the details of the names of the patients, their conditions, any sort of do not resuscitate requests, those sorts of things. But unbeknown to them, for about an 8-week period, they were faxing them to a fax number that was a private individual. They ended up being fined £90,000, but I don't know what happened to the person who would have been faxing, but I think that was a systemic failure in terms of there was no check that the faxes were actually being received by the hospice. They were being sent to several different numbers, and no one thought to have any sort of checks or measures in place to make sure they're actually getting through to the right people. And that particular trust self-referred to the Information Commissioner as well. So when it comes to the Information Commissioner, they don't care whether you self-refer or you get reported. Okay, cheers. Computer screens, just be conscious if you are using a computer and you step away from that computer to go and make a cup of tea, a cup of coffee, if it's in a public place, you could have anyone at work potentially walking past that computer, may see sensitive information, so use screensavers, log out, those sorts of things. Conversations, be very careful where you're having conversations and who you're having those conversations with. Even reading materials, actually. It's recently I had a union rep that said that she had seen a lawyer, which thankfully wasn't me, reading a file of papers on a train, and she could read everything that was going on in this case, and she was thinking about making a complaint to the Information Commissioner because she got the name of the law firm. I don't know what happened about that. Disclosing content. I mean, ultimately, the rule here is do not disclose content without consent. And that'll be the consent of the service user. The only time that you could potentially disclose any information without consent is when there is a risk of serious harm to either that particular service user or to another person, or to prevent serious crime occurring. But that's probably very, very rare that sort of situation is actually going to arise in day-to-day life, although it will probably arise in Frankie next episode. Finally, a quick look at fitness to practice. I mean, your regulator, it's the Nursing and Midwifery Council. God love them. God love them, but no one else does. They are notorious, and I don't know how they've got into the state that they are in, but unfortunately they're very disorganised. And I've got files that date back, probably like 4 or 5 years in terms of the allegations that we're dealing with, which is very unfair on that registrant to have been put in that position for as long as they have been. And that's not uncommon, unfortunately. They are making efforts to change their practice, because ultimately, if they don't, they will end up being defunct and their powers will go elsewhere, possibly to the Health and Care Professions Council, but who knows. There are nigh on 700,000 registrants registered with the NMC. And I won't ask for a show of hands about who has been referred to the NMC, hopefully no one, but it's a horrible experience, and there's no way of sugarcoating it. It's incredibly stressful. It's not necessarily the end of the world. Do not panic. Unite will assist you in terms of the representation that you need, and referrals can be made to law firms in terms of the representation that you may need at interim hearings or substantive hearings. There are 4,000 referrals made every year at the moment, so that is by no means a small number. You may feel alone, but you are not alone. Not all of those referrals will end up before a substantive hearing. They may get weeded out at the investigation stage. But once you're in the process, it's quite difficult, really, to get out of it. Who refers? Ideally, a self-referral, that always goes down a bit better. But an employer quite frequently now refers. If you find yourself going through, not necessarily disciplinary, but certainly dismissal, they will probably look to refer at that stage. Service users refer because of that complaints culture. If anything arises in the press, someone at the NMC sees it. That's how one of my referrals cropped up. Not my referrals, but one of my clients. That's how she found herself before the NMC, because someone at the NMC saw a press report relating to an incident she was involved in. It could be an anonymous box of papers that are left at the foot of the door. Once they are aware of it, they have an obligation to investigate. Their remit is to protect the public and to uphold the standards of the profession. It's understandable. There are two types of committee that you could find yourself before: a conduct and competence committee, which is the most popular. But if your health has been a factor in terms of the practice that you have been undertaking and any shortcomings in it, then the NMC will refer the matter to a health committee that has a medical professional sitting on it, and it's kind of beneficial in terms of they can't strike you off if you go before a health committee. There are 3-stage tests at the Health Professions Council, not Health Professions Council, the other one, the Nursing and Midwifery Council. There's the fact stage. Record keeping does come up incredibly frequently, and even if the allegation that has been made is one in terms of poor client care, certain things, or a tone that you may have had with a particular service user, the first port of call will be the records, and if the records are not up to scratch, you will find yourself in trouble because of the record keeping alone. It's not the end of the world to admit facts, to admit, hold your hands up and say, yeah, on that day, didn't actually practice to the standard that I generally practice to, and I made a mistake and I did X, Y, and Z, or I didn't do X, Y, and Z. Because the facts is only the first stage. Then the panels will always go on to look at impairment, and there's no definition of what impairment is. It's effectively whether you are, or whether the registrant can remain on the register without restriction. The test for impairment is a current test. So in terms of the delays between an allegation being made and an actual hearing being achieved, in that 2 or 3 year period, the registrant could have undertaken all manner of training, especially if the issue is record keeping alone. There are a number of record keeping courses you can do, internal clinical audits. As long as you have all those sorts of things that are coming up to scratch, it'd be very difficult for the panel to say that your current fitness to practice is impaired. When it comes to sanction, I'm afraid I can't stand here and say that there's one particular sanction that will apply in record keeping cases. The range of sanctions available to the committees is quite wide. They can only impose a sanction if they have found that current fitness to practice is impaired. They will start with the possibility of taking no action, but invariably, if they found that the fitness to practice is impaired, they're not going to take that course of action. Then it goes from a caution, conditions of practice, suspension, and then the ultimate striking off. Generally, in the cases that I've been involved in, really we're looking at sort of cautions and more frequently conditions of practice when it comes to issues with record keeping. But if it is prolonged issues with record keeping, and I've got one at the moment who's a social worker, and it's poor record keeping over a 2 year period, and some, it's going to, that is more difficult to counter than the odd example that may be pulled up in some sort of internal audit. But ultimately, if you were to ever be referred to the NMC, just don't panic. That it's not the end of the world. It doesn't mean you're necessarily going to lose your right to practice. It just means you're just going to have a pretty tough time for a bit, unfortunately. And that, as they say, is that. I have come to the end. So thank you very much for listening.
Thank you very much, Jo. Questions, comments? We have somebody straight away. One, and then you, please. So this lady first. Thank you.
Sorry, can you just clarify about signing records? If you are writing retrospectively and you've done a visit, that time you sign, are you saying you're signing the time that you wrote the records, or are you supposed to put the time that you did the visit? That's not quite, you didn't make that quite clear.
Right, okay. If you're writing a note in retrospect, then the time that you actually made the visit should be evident in the notes, but also the time and the date that you're making the note in retrospect. So in that sort of situation, it would be a twofold entry, if you like. Clarity. I mean, it's all about clarity. It has to be clear to someone when you did something and what you did, and then when you wrote up that record and you know the time that you did that. Does that answer? Yeah, it's I mean generally it would be sort of is a hospital environment known as the acute environment. Yeah, so it's the acute environment sort of on wards and what have you that you would always find that there are times for events and observations and all those sorts of things. When you're out and about in the community, I think best practice would be to include times in the notes. It avoids any manner of confusion then if someone's saying that no, you didn't attend on that particular day, and that can sometimes be one of the complaints that arises when records or your performance in a workplace is being assessed. Sometimes the diaries don't match, or the office diaries don't match up to your personal diaries or the clinical notes. So if your notes are as full as possible to show when you were there or when you have written that note in retrospect, then there's less of an argument, and it's about you looking after yourself. That's all right.
Could I ask a question, please? I'm working in Northern Ireland, and in the trust I work in, we keep electronic records. So when we make a home visit as a health visitor, we don't have access to laptops. So we are carrying our paper notes. So we have to record, scribble down or whatever, because we don't carry out family health assessment records, nothing. So we only have our jotter. We take down whatever notes we have, plus we have the child record, the little red book as we call it. And then we go back to the office. But we may have done 3 or 4 or 5, 6 visits in that day. Yeah. So you're going back and you're then trying to get it on the electronic system. So what becomes of that paper record where you have jotted down things? Should we be holding those records, or can we then scrap them because they're now on the electronic? But the timing is different because we've recorded them in the house as the mother's speaking, and then we're transferring them onto electronic record within maybe, 24 hours, as soon as possible, let me put it that way. So just one clarification, what we should do with the original records that we have written on. Do we have to keep them?
Strictly speaking, at the point that record is made in writing, then that becomes the person's health record. Once that health record is then inputted, I suppose, as an electronic record, and if that is your employer's method of keeping the patient records, then, do they have a means of storing the paper records? No.
No, we have folders, but we don't we have the centile charts on that in the folders, but we don't keep the written records. We're not supposed to keep duplicate records.
So I'm assuming that they are destroyed in a confidential manner, are they, like incinerated or shredded or something like that? Yeah. Until they are inputted onto the electronic system, they are the patient notes, and so they are paramount. I think at the time, once they are inputted into the electronic system, and if that is your employer's method of maintaining a patient record system, and there is no means of having a paper record system, I think as long as they are destroyed in a secure manner, then you're doing as much as you need to do.
Okay. There's one more. I think there was somebody over there. What I'm going to do, by the way, keep you all informed, we're rejigging the programme, okay? So I'm going to take one more question for Joe, because Joe is going to be on the panel later this morning, and then we're going to have our coffee break. We're going to have a 20-minute coffee break at 10:30. Is that all right? Good, because that's what we're going to do. Yes. So over to you. Thank you.
It's more of an observation, really, about what you were saying in the presentation, but it was really good to hear that I think the focus on record keeping sometimes can be about covering people's backs, and people forget sometimes about, as you said, about that it's a really vital opportunities to identify risk, to show the patient's journey. And I think in training in record keeping that, sometimes gets forgotten as well. And within the trust I work in at the moment, I'm in safeguarding, and we're looking at trying to develop writing to safeguard as well, really, because I think a lot of record keeping training focuses, as you say, very much on the no jargon, the initialing and things like that. But where we're finding a lot of records are failing, particularly when coming to do court reports or everything, is the actual particular content and how people have written the content in their records. And I was wondering if anybody, I also tried to do a search of useful information to support kind of good writing of records rather than the basics. Have come across anything in relation to safeguarding, really, for writing records for supporting good safeguarding?
I mean, I haven't come across anything. That's not to say it doesn't exist. I mean, generally, any guidance that comes out on record keeping doesn't really touch on the verbatim, I suppose, really, and the level of content. As much as anyone ever says is about as much as anyone else would need to know if they were picking up the notes.
Does anybody in the audience have an example specifically on the...
We had a recent, we had an inspection last year, and it was there was a comment made by Ofsted CQC about the voice of the child and how that was reflected in the style of the practitioner's writing. A lot of practitioners, like you say, feel that they were being child-centric. They felt that how they wrote their records reflected that. But we have had a problem with one case, especially where she was told that the voice of the child wasn't relevant, but she'll argue till the skies turn that the notes were child-centric, and how you reflect that and how that is shown in the notes. What one practitioner reads and sees child centricity and one calls voice of the child has become an issue in our area. We're finding it a little disconcerting because obviously it's not black and white, is it? It isn't like, is the signature there or isn't it? It's about writing styles and it's about making sure it's accurate, but you're not also making assumptions. So that has been something that we welcome a discussion on.
Is this... Oh, sorry, yes.
In terms of voice of the child, I'm a designated nurse job search and I'm going to do the talk after.
Oh.
But the child's development is the voice. If you talk about the child's development,
Thank you very much for that input. Now we're going to, could we show our appreciation of Joe?